Good morning, everyone, and welcome to Compliance Corner with John Hanson. Today is Thursday, April 9th, and I am here with my good friend, John. John, how are you doing this morning?
Doing wonderful, thank you.
I am so glad to hear that. Okay, so there is an intersection where the Form 21, time is of the essence, and the new 22 FM force majeure seem to be colliding. So what I wanted to do first, wanted to share with everybody, and I'm hoping you and I can have a little bit of discussion about this, of kind of defining these two things. So if we're in the Form 21, paragraph L, which is time is of the essence, that's our computation of time conversation or clause. The very end, though, it says time is of the essence of this agreement. So again, that is the paragraph 21, or the Form 21 paragraph L, computation of time. So John, can you and I chat just a bit about, let's define that first of all, before we kind of go where everything collides. Can you and I have a conversation about what time is of the essence means in computation of time?
Yeah, so it's really common for a contract to have that wording in it, and courts have ruled that whenever a contract contains the wording time is of the essence, it means that all timelines and all agreements between the parties to meet timelines will be held to exactly. So there's not a grace period of 1 day, there's not a grace period of 2 days or 3 days. These time periods will be held to exactly. So when there's a 10-day inspection period and it's day 11, that inspection contingency has been waived if it hasn't been addressed. So anyway, so that's time is of the essence. Closing date, same thing. The closing date's there. The buyer can't close until the following day. Technically, according to the contract, time is of the essence. And unless the seller agrees to extend, we have a dead deal.
Great. So this is what all of us are really normally used to, is, and we've gotten very good at computation of time, I think, as a real estate broker community. So now where things kind of get a little bit wonky is because of our current situation with COVID-19. So I want to go back again, and let's take a look at now a different thing. So this is in now the new paragraph 1 of the new Form 22 FM, the force majeure. And in particular, actually, let me go ahead and read this. It's neither party shall be liable to the other or deemed in default under this agreement if and to the extent that such party's timely performance of this agreement is prevented by reason of a force majeure event. Force majeure event means an occurrence that is beyond the control of either party affected and could not have been avoided by exercising reasonable diligence. Paragraph goes on to talk more about that. But when we're really talking on this one, means an occurrence that is beyond anyone's control. Okay, so when we are talking about beyond anyone's control, so now we've got a contract and the parties have agreed, and now something has occurred that is beyond either party's control and is a force majeure. When we're talking force majeure, when would we know that we actually need to either add that into the contract, or the force majeure has already taken place and we need to use that 22 FM in the contract?
Well, first of all, the force majeure clause is a clause that is really common in most all contracts. So you sign your gym membership, that gym membership contract is going to have a force majeure clause. I mean, it's just very common. So our purchase and sale contract doesn't have one, which is unusual, but because of the circumstances that have come up, we have an addendum that has been done up to add to that. And let me just also mention that this week we had a situation where a title company, escrow company, was not going to accept a contract with a force majeure addendum, the 22 FM, because it was too vague. And so clearly this was an individual making a decision who didn't understand contract law, because it's a very common clause that exists in contracts. And yes, it casts a little bit of a shadow of doubt on things, but my advice to that broker was buyer and seller should consider seriously switching escrow companies and find one that will work with our forms. And so that's the answer to that. So the vagary of a force majeure clause is if a party is using it, buyer or seller is trying to use it to manipulate the close date or to manipulate their inspections period, or whatever it is. And so ultimately
let's take a look at the next language if we can, John, because I think that's really important to the conversation that we're having right now. Now in the paragraph 2, we're talking about the contingencies, right? And there's a piece of it, I think, that this is where I think the confusion may start happening here. It's if through no fault of the buyer or seller and by reason of a force majeure event, any contingency or condition in the agreement cannot be timely completed, then all time periods in the applicable contingency or condition, including the time periods for the related notices and responses thereto, shall be extended for up to however many days, 10 days if not filled in, and shall be completed as soon as reasonably practicable. So time is of the essence now, starting, and then soon as reasonably practicable. All right, so let's kind of get into that conversation, because I know that you had some challenges with that. So let's finish first of all what you're talking about the title and escrow company, why they wouldn't accept it. And then maybe you could talk a little bit about where you've seen some conflicts in this over the past few days.
Okay. Okay, so the force majeure paragraph 1 is the definition of it, and then paragraph 2 is the paragraph that addresses conditions of the sale to be met, and has a default of 10 days. So the purpose of that is the classic example we have just experienced just a little while ago, is when there was an order from the governor that everyone's to stay in their houses, and there were no exceptions for real estate people at that time, right?
Right.
And so we had inspections that were to be performed in 10 days, and suddenly they couldn't be performed. People had to stay in their houses and couldn't let anybody in their house. So that was that's a good example, I think, of this force majeure clause. If it existed, it would say that things would be extended to accommodate that inspection period of 10 days, and would be extended. Of course, the seller doesn't want to have that happen. The seller, of course, wants to have the buyer's inspection period end as quickly as possible. So they would try to go to paragraph L, the last sentence, and say time is of the essence. But the buyer would be saying, no, we've got a force majeure addendum here, the 22 FM, that says that it's beyond our control, so it's to be extended. Okay, so our job as realtors is to not really take one side and the other and try to be very rigid on it and that kind of thing. It's to try to make this thing happen as reasonably as possible.
Right, and let's take a look at, so a legal bulletin 218 came out. about this. And I won't read all the way through this, but there was a very, very particular statement in here that I think is incredibly important. Basically what it says is the listing broker and the selling broker should cooperate to work together to ensure that all parties have the same expectations. So this is about cooperation. This is about, and I know you've talked about this before, John. You've really talked about the spirit of the law, or certainly the spirit of the contract here. Have you seen any issues where people maybe are not acting in the spirit of which the force majeure is being used in our current situation?
Well, yes, and so an example would be that comes to my mind because it happened so recently, was a seller. We represented the buyer. The seller wanted the deal to go away and die because they had another backup buyer that was going to bring in more money, and so they were hoping that the first one would die, and they were unwilling to extend for any reason. They wanted to hold to that paragraph L, the last sentence, time is of the essence. And they wanted to hold to that and say, if you can't close, we're moving on. And the buyer wasn't going to be able to close until the next day. And so reasonably, given the circumstances, it would seem that would, be the case had there been a force majeure clause in the contract, that would be the case. So what we want to understand about this is that if there is a collision, if there is a discrepancy between the force majeure addendum clause and the time is of the essence clause, then it's going to be up to a court to decide it. You and I can't decide it. Right. To go to a court, we already know how expensive lawyer fees are. Mm-hmm. I hope that we all know that. They're very expensive, and the court costs themselves can be expensive. And per our paragraph P of our contract, the loser in a court action has to pay the winner's court costs. So in other words, the stakes are extremely high in this thing. And so it is in our client's best interest and our best interest to try to make this thing as reasonable as possible when there is that collision between the force majeure clause and the time is of the essence clause. And so we want to not have our client put in a position where they're having to pay tens of thousands of dollars in legal fees, right, to enforce something to save them a couple of $1,000s. It just doesn't make sense. So we want to, in this environment, we want to try to work through things as best as possible and counsel our clients that the only way to enforce a contract is to go to court, and so that is going to be an expensive venture and a risk for both sides.
Exactly. So best practice is, and as we're talking about this in this particular situation, yes, maybe the seller was going to get more money, but here's what they didn't have already, perhaps, is there's inspections to be had. There's other timelines and actions that need to take place, appraisals. All of those things are not guaranteed. And so we, as a best practice, once we get into contract, helping our clients understand that it is in everyone's best interest, especially right now, to be cooperative, to stay with the terms of the what they've agreed upon, and being able to use the force majeure is really best practice right now. And especially if you're going into contract right now, automatically go ahead and include that Form 22 FM to make sure that everybody is cooperating and everybody is agreeing in advance to any issues that may come up regarding the force majeure.
Yes, absolutely.
Okay, fantastic. Well, this was really important, John. I know when you and I were talking about it this morning, it's fascinating, where these two kind of things can collide. So I so appreciate you clearing it up for everybody. And this has been fantastic. So John, thank you so much, as always, for bringing clarity to these situations. I know all of us truly do appreciate it. And I hope, my friend, you have a fantastic rest of your day.
Thank you, Kole. You too.
Bye.
Bye-bye.